Should those with a mental illness be allowed to scare and stalk our wives and daughters in pursuit of their disease? Can public schools protect our young ladies, or shall mental illness supersede the law, biology, and even common sense? We'll discuss this next on the Constitution Study.
Love your neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach our generation be free. Glad you could join me today. Of course, transgenderism has been in the news in a lot of different ways recently, and, well, it's made its way all the way to the Supreme Court. We're going to look at that case in a few minutes. Before I do, though, if you want to follow along, head to the website, constitutionstudy.com, and, well, look at the article. I've got all my quotes with all the links to my sources so you can follow along and double-check my work. I'll talk more about the website and what you can do there at the end of the episode, but for now, let's get into the Supreme Court case about, well, boys and girls. What are little girls made of? Well, the nursery rhyme says sugar and spice and everything nice. The truth really comes down to biology. The question before the court in these cases is whether, under Title IX and the Equal Protection Clause of the 14th Amendment, schools may maintain women's and girls' sports teams for biological females, i.e., may schools determine eligibility for female sports based on biological sex. In the past 6 years, 27 states have enacted laws that maintain female sports for biological females. Are girls and women's teams only for the female of the species? At least 27 states have enacted laws saying so. West Virginia's law has been challenged. In 2021, West Virginia enacted the Save Women's Sports Act, which prohibits male students from playing on female teams. The law specifies that sex is determined by biology. The legislature expressly found that prohibiting biological male participation in female sports is necessary to promote equal athletic opportunities for women and girls. Seems pretty straightforward to me. Male students are prohibited from playing on female teams, and that distinction is made by biology. Respondent, BPJ, who identifies as female, is a biological male. I can claim an identity as a tuna fish sandwich, but that does not make it so. Neither is what a person thinks about themselves a scientifically or legally established fact. BPJ has sought to participate in girls' cross-country and track and field teams at school. BPJ sued West Virginia and relevant officials for alleged violations of Title IX and the Equal Protection Clause of the 14th Amendment. BPJ is a boy who wants to play on girls' athletic teams. He claims that West Virginia's laws prohibiting this violates both federal law and the 14th Amendment. What do the courts think about this claim? The U.S. District Court for the Southern District of West Virginia granted summary judgment for the state on both claims. On appeal, the Fourth Circuit reversed on a Title IX issue and remanded for further fact-finding on the Equal Protection Clause claim. So the district court said the state was correct on both claims, but the Fourth Circuit disagreed, at least on the federal law question. West Virginia wasn't the only state sued. The facts in both of these cases are very similar. In 2020, Idaho enacted the Fairness of Women's Sports Act, which prohibits male students from participating on female teams. The Idaho law states that sex is determined by biology, and the law declares that separate sex-specific teams furthers efforts to provide sex equality by providing opportunities for female athletes. It also recognizes the physical difference between biological males and biological females. The law further found that the benefit that natural testosterone provides to male athletes is not diminished through the use of puberty blockers and cross-sex hormones. Sounds almost identical to the West Virginia law. I think you'll find the complaint similar, but not identical. Respondent Hecox, who identifies as female, is a biological male as defined by the Idaho law. Hecox competed for the women's club soccer team and tried out for the women's Division I track and cross-country teams. Shortly after Idaho enacted the Fairness in Women's Sports Act, Hecox sued Idaho and relevant officials, alleging a violation of the Equal Protection Clause. The U.S. District Court for the District of Idaho granted a preliminary injunction barring enforcement of the Fairness in Women's Sports Act, and the Ninth Circuit affirmed. Mr. Hecox doesn't argue a Title IX violation, only an Equal Protection Clause violation. Now let's start by looking at the arguments for Title IX. Title IX provides no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefit of, or be subject to discrimination under any education program or activity receiving federal financial assistance. Keep that last few words in mind because federal financial assistance is actually a very important point in this case. 2 years after Title IX became law in 1972, Congress passed the Javits Amendment, which directed the then Department of Health, Education, and Welfare to promptly issue regulations implementing the provisions of Title IX with respect to the prohibition of sex discrimination. The amendment further specified that the regulations shall include, with respect to athletic activities, reasonable provisions considering the nature of particular sports. In 1975, HEW promulgated comprehensive regulations requiring that schools provide equal athletic opportunities for members of both sexes and authorizing separate teams for members of each sex where selection of such teams is based upon competitive skill or the activity involved is a contact sport. So the claims in this case are not so much a violation of federal law, but of federal regulation. That too is important since federal regulations are not the supreme law of the land. The term sex in Title IX, the Javits Amendment, and the Title IX regulations cannot plausibly be interpreted to refer to anything other than biological sex. The ordinary meaning of the term sex at the time of the enactment in the 1970s was biological sex and not gender identity, particularly in the sports context. The phrase biological sex is redundant. After all, sex is defined as either of the two major forms of individuals that occur in many species and that are distinguished respectively as female or male, especially on the basis of their reproductive organs and structures. Since sex is determined by the biology of the individual, biological sex is, as I said, redundant. In addition, Title IX regulations allowed separate sports teams precisely because of the inherent physical differences between biological men and biological women. So the question isn't about the separation of sports teams based on sex, but apparently the definition of sex itself. While BPJ agrees that Title IX permits schools to maintain separate female and male teams and to prohibit most biological males from playing on women's and girls' teams, BPJ argues that schools must make an exception to that general rule for biological males who identify as female and have taken puberty blockers or hormones. Apparently, BPJ believes that male and female are defined at puberty, not conception. What else would make males who have taken puberty blockers be considered female? Is that supposed to be the law? But the text of Title IX, the Javits Amendment, and the Title IX regulations do not support that argument and do not speak to that issue in a way that could properly be interpreted to require schools to allow biological males to participate in women's and girls' sports. BPJ argues that if the regulation authorizes a school to limit female sports to biological females without exception, then the regulations are not reasonable as required by the Javits Amendment. Is it reasonable to allow males to participate in female sports? That is the real question. As Justice Kavanaugh wrote in the majority opinion, the court concludes that separate sports teams for biological males and biological females are reasonable given the inherent physical differences between the sexes. In assessing the reasonableness of the regulations, the court must recognize the distinctiveness of competitive sports and the safety and competitive fairness issues that can arise when females are forced to compete against males. You know what is unreasonable? BPJ's other Title IX assertion. BPJ contends that the school's policy violates Title IX because the policy effectively excludes BPJ from entity competitive sports teams at the school. No one that I'm aware of is prohibiting BPJ from all competitive sports, only sports for which he is not qualified, as the court pointed out. While it is an unhappy occasion whenever a student who wants to play sports cannot do so, the Title IX regulations guarantee only equal athletic opportunity. Title IX does not guarantee you a spot on a team, only equal athletic opportunity. The second claim of these cases is that they violate the Equal Protection Clause of the 14th Amendment. The argument that the challenged laws unconstitutionally discriminate against transgender individuals is unavailing. Under this court's decision in Scrimetti, the challenged law does not classify based on gender identity or transgender status, but instead on the basis of biological sex. The classification at issue readily satisfies a rational basis review or intermediate scrutiny. Now, Justice Thomas filed a concurrence which makes an additional point. As the court recognizes, this case concerns biological men and boys who identify as girls. Men and boys with gender dysphoria are not women or girls, even if they believe they are. Sex is an immutable biological characteristic. It is binary, and man and woman, boy and girl are the terms that correspond to adult and children of each sex. A man is not a woman simply because they believe they are. This biological fact is at the heart of this case and all transgender issues in this nation. Sadly, that basic fact is often lost, even on the Supreme Court justices. Before I get to that discussion, Justice Gorsuch made another point I need to get back to. That of federal financial assistance. What seems lost in most conversations about Title IX is the fact that the law is not about regulating sports, but about spending money. As Justice Gorsuch wrote in his concurrence, Title IX was enacted as an exercise of Congress's power under the spending clause. The question no one seems to have asked is if Congress had the authority to spend money on education. The answer is no. Article 1, Section 8, Clause 1 of the Constitution says, the Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. Education is not a payment of debts, the common defense, nor the general welfare of the United States. The United States is a proper noun, referring to the union of states whose government is seated in Washington, D.C. So all of this started with Congress embezzling trillions of dollars to influence and regulate something they're prohibited from regulating. That provision of the Constitution does not allow Congress to regulate conduct. Instead, it only authorizes Congress to spend money. Of course, Congress may seek to condition the funds it gives to others, but much as with any contract, a funding recipient must voluntarily and knowingly assent to those conditions for them to bear any legal force. And as with any funding contract, the funder must be legally authorized to spend money on the contract. Since the 10th Amendment, the Necessary Proper Clause, and the Spending Clause make clear Congress can only legally spend money on three things, and education is not one of them. Now, both Justices Sotomayor and Jackson wrote opinions where they concurred in part and dissented in part with the majority. However, both of their dissents start with a lie. Respondent BPJ is a transgender girl who wants to live her life consistent with her gender identity. BPJ is not a girl, he's a boy. He may think he's a girl, but that doesn't make it true. As Justice Thomas pointed out, men and boys with gender dysphoria are not women or girls, even if they believe that they are. Justice Sotomayor's opinion introduces another lie as well. When BPJ was 11 years old, she sought the opportunity to do what she and so many other children love to do, play sports. In order to do so, BPJ needed to turn to litigation because West Virginia banned all transgender girls from playing in girls' sports from middle school through college. I'm not aware of a single person that claims that BPJ should be banned from all sports, only that he not be allowed to play on girls' teams. Put these two lies together, and we appear to have the bedrock on which Justices Sotomayor and Jackson rest their opinion. But the lies aren't done. Applying a form of heightened scrutiny divorced from this court's cases, the majority holds that transgender girls like BPJ who wish to play girls' sports are not protected by the Constitution, even if BPJ is correct that neither of the state's interests is furthered by their exclusion. Justice Sotomayor appears to claim that BPJ is somehow not protected by the Constitution because he wishes to play on the girls' team. The Constitution doesn't protect a person's right to play on a particular team, though, especially when doing so deprives the others on the team of their rights to the equal protection of the law. Meanwhile, Justice Jackson, in her opinion, promulgated another lie. As the majority notes, BPJ does not argue that sex in Title IX means anything but biological sex, that is, sex assigned at birth. Sex is not assigned at birth. It is a function of conception. Sex is determined when the sperm enters the egg. If the sperm has an X chromosome, the baby is a girl. If the sperm has a Y chromosome, the baby is a boy. No doctor has ever held up a newborn baby and assigned them a sex. They determined the sex based on the obvious biology observed, which was determined by the child's genetics. They did not assign a sex to them. I guess Justice Jackson failed that part of high school biology, which may explain why she couldn't define a woman during her confirmation hearings before the Senate. Now, what was the majority opinion of the court? Held. Title IX allows schools to provide separate women's and men's sports teams defined by biological sex, and West Virginia has permissibly maintained female sports for biological females consistent with Title IX. West Virginia and Idaho did not violate the Equal Protection Clause of the 14th Amendment by maintaining female sports teams for biological females. West Virginia and Idaho were perfectly within their rights to maintain sex-separate sports teams and to enforce that separation. As the court noted, Title IX regulations guarantee only equal athletic opportunity. Allowing males to compete in female sports denies women and girls equal athletic opportunity. The basic biological advantages that men have in physical activities is the very reason schools created separate female and male sports teams. So it is BPJ, Hecox, and all the other transgender promoters who are violating Title IX by denying women and girls an equal athletic opportunity in their promotion of their mental disorder or political agenda. It really is sad that we have to explain this idea of transgenderism being a mental disorder, being not a physical requirement, that you have to explain to justices of the Supreme Court that sex is not assigned at birth, that biology is not a choice, that a person is a boy or a girl based on their genetics. That really is a sad state of affairs for American society, is it not? What about the rest of us that can't understand the difference? I mean, I grew up understanding the difference between a boy and a girl. It's not that hard. But we've let these people with an obvious mental disorder, an inability to understand their biology and to live with their biology, as somehow beginning to rewrite reality itself, not just deal with their mental disorder. And I feel for them. I wish they could get the help that they need to deal with their mental disorder. But to cling to rewrite reality as a whole, well, that's a whole other mental disorder. And the majority of the court got it right. When Title IX, when it says you can have separate male and female sports teams, it meant male and female sport team. It didn't mean male and female sports teams that include men who think they're girls. They got the right answer. And I'm glad they did. And I really think that Justices Sotomayor and Jackson really kind of beclown themselves with their dissenting parts of their opinions. But then again, I'm not really surprised. Now, if you want to find out more, again, I put the article on the website with all my sources so you can follow the links and check them out for yourself. I hope you do. While you're there, hey, maybe sign up for a mailing list. Get notified when I release these articles and episodes, or follow my news feed as I share news that I think is interesting. Of course, you can also head to the store, constitutionstudy.com/shop, and, maybe buy a book or a t-shirt or just donate to the cause. See, nobody here makes a salary. So whatever you donate, whatever you buy, all the proceeds go to keeping the Constitution Study up and running and to helping me bring this message to other people. See, when I speak at events, I try not to charge people. So when you buy a book or you donate to the cause, you're helping me to speak to more people, to bring them this education without having to charge them for it. I think that's really important. And I love it when people can help. Of course, you can also help me with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider, but that's not why I joined them. I didn't join them for their 4G and 5G coverage, even for their 100% US-based customer support. I joined them because they put their money where their mouth is. They support organizations that are defending your rights, like the Constitution Study. Places that are defending your freedom of press and speech and religion, your due process rights, even your right to be secured from unreasonable searches and seizures. Join me today by going to patriotmobile.com/constitution, find a plan that works for you, and whenever you pay your bill, you're helping to support the Constitution Study. See if you're eligible for a discount. Veterans, first responders, even families with multiple lines get discounted service, which means you can have more service for less money. And if you use the code Constitution at checkout, you get activation absolutely free. So you get great cell phone service, 100% US-based customer support, and support organizations like the Constitution Study that are defending your rights by going to patriotmobile.com/constitution, finding a plan and discount that works for you, and then use that code Constitution today to get free activation. Most of all, I hope you enjoyed this episode. I hope you learned something, and I hope you'll share it and all the work we do here. Hey, maybe you'll come back next time with a friend or two when we get together for the Constitution Study.